Chapter 9, Order for Maintenance of Wife, Children and Parents. Although this is one of the smallest chapter containing only 4 sections, 125 to section 128, but this has taken the maximum time of the courts. The maximum cases are regarding the maintenance of wife. It is actually natural and a fundamental duty of every person to maintain his wife and children so long as they are not able to maintain themselves. And the maintenance of the parents are also regarded as a sacred duty if they are not able to maintain themselves. The provision of the code under this chapter give effect to this natural duty of a man. Coming back to the chapter, it has 4 sections. Section 1 is Section 125, Order for Maintenance of Wife, Children and Parents. Next is Section 126. This informs us regarding the procedure of action to be taken under Section 125 who is refusing or fails to maintain his wife. Next, third point, Section 127, Alteration in allowance, whichever has been given, and last one, Section 128, Enforcement of Order of Maintenance. Before we start this chapter, a small message. Girls and guys, before I begin this chapter, let me tell you that this is section 125. If you are going to be on civil side, you are going to deal section 125 throughout your life. So you need to understand each and every single word given under section 125, which is order for maintenance of wives, children and parents. Subsection 1 of section 125 says, if any person having sufficient means neglects or refuses to maintain the following. Clause A says his wife who is unable to maintain herself. Next, clause B says his legitimate or illegitimate minor child, whether married or not, but he must be unable to maintain itself. Third point, clause C says his legitimate or illegitimate child not being a married daughter who has attained majority, whether such child is by reason of any physical or mental abnormality or injury unable to maintain itself. Or the fourth point, that is clause D, it says his father or mother unable to maintain himself or herself. So, when a complaint under Section 125 is received, a magistrate of first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child. Such child includes a legitimate or illegitimate child, or may also order a monthly allowance to father or mother as the case may be, at such monthly rates as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct. Time to time direct means he can even change his decision. The monthly allowance can be raised or even can be reduced as per the situation or condition of the person earning. There is a condition to it, provided that the magistrate may order the father of a minor female child referred to in clause B to make such allowance until she attains her majority. If the magistrate is satisfied that the husband of such minor female child, if married, is not possessed of sufficient means. Next condition is provided further that the magistrate may, during the pendency of the proceedings regarding monthly allowance for the maintenance under this subsection, order such person to make a monthly allowance for the interim maintenance of his wife or such child, father or mother, and the expenses of such proceedings which the magistrate considers reasonable, and to pay the same to such person as the magistrate may from time to time direct. See, this is very important for every student and every advocate because the cases everybody knows takes time, and when an application for maintenance is made under section 125, obviously either the wife of the person, by the child of the person, or even by the parents, father or mother of the person to maintain him or them, the person against whom such application is made to maintain them may even hire an advocate to defend the case that he need not maintain them. So that is going to take time to be decided by the court whether they need to be maintained or not by the person as per the provision of 125. By that time, the person requesting the court for maintenance under section 125 has to move another application for interim maintenance, and yes, the court will definitely give interim maintenance during the pendency of the case. So all the guys out over there, let me suggest you that do take care of your wife, otherwise if she takes you to the court, she will take a lot of money out of your pocket. Do you see that? If you can't see that, go to any courts and you can see the reality. I'm not saying that this is badly done by the women, but because men don't maintain them. And you know what? There is another condition to it, provided also that an application for the monthly allowance for the interim maintenance and expensive of proceedings under the second proviso shall, as far as may possible, be disposed of within 60 days from the date of the service of notice. Which means, man, this decision gonna come out within 60 days. Less than 60 days, actually, it's happening in reality. So, bad guys all over there, beware, section 125 is out there for you. Maintain your wife yourself, or court will ask you to maintain them. Now the code is explaining us the two words used under the section. First one is minor. Minor means a person under the provisions of Indian Majority Act 1875 deemed not to have attained his majority. The second word, wife, used in the section means and explained as a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. This explanation was required because sometimes the person takes divorce from the wife and the divorced wife does not know the rights that she can claim the maintenance, and she can claim the maintenance even after the divorce. But the condition is she should not have remarried. Further, subsection 2 of section 125 speaks about the allowance, that any such allowance for maintenance or interim maintenance and the expenses of proceedings shall be payable from the date of the order, or if so ordered from the date of the application for maintenance or interim maintenance and the expenses of proceedings as the case may be. So, subsection 2 of section 125 explain us that the allowance will begin from the date when the order has been made or from the date of the application. So, it depends upon the decision of the magistrate. Next, subsection 3 of section 125. It says if any person so ordered fails without sufficient cause to comply with the orders, any such magistrate may, for every breach of the order, issue a warrant for levy the amount due in the manner provided for levying fines, and may sentence such person for the whole or any part of such month's allowance for the maintenance or interim maintenance and expenses of proceedings as the case may be, remaining unpaid after the execution of the warrant, to imprisonment for a term which may extend to 1 month or until payment if sooner made. This means that when a person is ordered under subsection 2 of 125 to pay the maintenance to his wife, son, daughter, or a mother or a father, if the persons even after such order does not maintain them, then subsection 3 of section 125 says that they can impose some fine on him and even can put the person in prison for a month or till the period he does not pay the maintenance to the family. There is a condition to it, provided that no warrant shall be issued for the recovery of any amount due under this section unless application to be made to the court to levy such amount within a period of 1 year from the date on which it becomes due. This means that there will be no immediate arrest. The arrest warrant will be issued only after checking that the application has been made for the recovery of the amount within a period of 1 year from which it became due. Another condition is provided further that if such person offers to maintain his wife on condition of her living with him and she refuses to live with him, such magistrate may consider any ground of refusal stated by her and may make an order under this section notwithstanding such offer if he is satisfied that there is just ground for so doing. See, every aspect of this section is very important. Now comes a situation where a man can say that I will maintain my wife only if she lives with me. Well, this is a genuine condition as well. But if the wife refuses to stay with him on the grounds that she fears to be insulted, abused, or even for her life, this is a condition where magistrate has to really go into the depth of the matter, that whether the maintenance has to be given to the wife even if she refuses to stay with him or not. Now we come to another explanation. It says that if a husband has contracted marriage with another woman or keeps a mistress, it shall be considered to be just ground for his wife's refusal to live with him. Marrying another woman is a condition where a divorce has been taken, and keeping a mistress is a condition where a woman is living with him even if the divorce proceeding is pending. Now comes subsection 4 of section 125. No wife shall be entitled to receive an allowance from the maintenance or the interim maintenance and expenses of proceedings as the case may be from her husband under this section if she is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. So there are three conditions in which a wife cannot claim a maintenance. 1. She is living in adultery, which means she is in relationship with another man than his husband. Number 2, without any reason she is not living with her husband. And number 3, they have mutually decided to live separately. You know what? This subsection 4 of section 125 has made every man to say that his wife is a characterless woman so that he don't have to pay allowance. What a shame. This is where I say that a person has fear of God only in temple, mosque or gurdwara, a church, as the case may be, and there is no fear of God in the courts just because they want to save their money. What a shame again. And on other hand, it's a shame on all those women who take the man to the court without any sufficient cause, but to take control of his money. Anyway, let's come back to the topic. Subsection 5 of Section 125 says, on proof that any wife in whose favor an order has been made under this section is living in adultery, or without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate shall cancel the order. Which means that even if the order has been made for to maintain the wife, if such conditions which is given under subsection 4 are proved, the magistrate can at later stage cancel his orders of maintenance. Now we come to the second point, that is procedure as per the provisions of section 126. Subsection 1 of section 126 says the proceedings under section 125 may be taken against any person in any district. There are 3 points to it. A, where he resides actually. B, where he or his wife resides. C, third point, where he last resided with his wife, or as the case may be, with the mother of the illegitimate child. So there is flexibility where the case can be filed. 3 options are given: where he was residing, where the wife is residing, or where both resided last together. Next, subsection 2 of section 126, it says, all evidence in such proceedings shall be taken in the presence of the person against whom an order for payment of maintenance is proposed to be made, or when his personal attendance is dispensed with, in the presence of the pleader, and shall be recorded in the manner prescribed for summons cases. This means that the proceedings shall be made in his presence, and if he is not present, the proceeding shall be done in the presence of his pleader and shall be recorded in the same manner as summon cases are done. There is a condition to subsection 2. It says, provided that if the magistrate is satisfied that the person against whom an order for the payment of maintenance is proposed to be made is willfully avoiding service or willfully neglecting to attend the court, the magistrate may proceed to hear and determine the case ex parte, and any order so made may be set aside for good cause shown on an application made within 3 months from the date thereof, subject to such terms, including terms as to payment of costs to the opposite party as the magistrate may think just and proper. Now the condition says that if a person is willfully avoiding or neglecting, he is deliberately not coming to the court, right? Then the magistrate will take a decision ex parte regarding the maintenance, but the magistrate can also set aside his decision if the person appears within 3 months from the date of such application. So time limit is over there, and let me tell you, the courts are strictly adopting this time limit. Now we come to the third point, subsection 3 of section 126. It says the court in dealing with such applications under section 125 shall have power to make such order as to cost as may be just. This means that along with the order of maintenance, the court will also order as to the cost of the case. Well, this means that any order made under section 125 can be cancelled or they can vary the same. Next is alteration in allowance as per the provision of section 127. Subsection 1 of section 127 says, on proof of a change in circumstances of any person receiving under section 125 a monthly allowance for the maintenance or interim maintenance, or ordered under the same section to pay a monthly allowance for the maintenance or interim maintenance to his wife, child, father or mother as the case may be, the magistrate may make such alteration as he thinks fit in the allowance for the maintenance or the interim maintenance as the case may be. Subsection 1 of section 127 is explaining us when it is proved that there are changes in the circumstances of any person. Now, any person over here means the person either who is giving the maintenance or the person who is receiving the maintenance. What changes it can be? The person who is giving maintenance might have started earning more, or might have started earning less. On other hand, the person who was receiving the maintenance might have started earning, which means that he does not need to be maintained anymore. So a divorce proceeding might come to an end, but such fight keep going on in the courts regarding the maintenance, regarding the alteration in allowance. Next is subsection 2 of section 127. It says where it appears to the magistrate that in consequences of any decision of a competent civil court, any order made under section 125 should be cancelled or varied, he shall cancel the order or as the case may be, vary the same accordingly. Well, this means that any order made under section 125 can be cancelled or they can vary the same. Next is subsection 3 of section 127, where any order has been made under section 125 in favor of a woman who has been divorced by or has obtained a divorce from her husband, the magistrate shall, if he is satisfied that, as per clause A, the woman has, after the date of such divorce, remarried, cancel such order as from the date of her remarriage. See, what happens in many cases that even after getting remarried, out of greed or out of, you can say, revenge, the women claim maintenance from their first husband. Or after getting a maintenance, they get remarried and they do not disclose such things so that they keep on getting the maintenance. So, such men can protect themselves under clause A of subsection 3 of section 127 that a woman has remarried and the maintenance order should be cancelled. Next comes clause B of subsection 3 of section 127. The woman has been divorced by her husband and that she has received, whether before or after the date of the said order, the whole of the sum which under any customary or personal law applicable to the parties was payable on such divorce, cancel such order. Now, sometimes what we have seen that on divorce, parties out of the court, they settle on their own as a one-time payment settlement, and if such payment has been given to the woman, then she cannot claim for maintenance thereafter. So it is very important to keep a proof of the payment done. Otherwise, you won't be able to claim the relief under clause B of subsection 3 of section 127. Next, we come to see 2 points where it is said that such cancellation of the order will be in the case where such sum was paid before such order from the date on which the order was made. And the second point, it says that in any other case from the date of expiry of the period, if any, for which maintenance has been actually paid by the husband to the woman. I have already explained this. And clause C says the woman has obtained a divorce from her husband and that she had voluntarily surrendered her rights to maintenance or interim maintenance as the case may be after her divorce. Cancel the order from the date thereof. Means if a woman says, I don't want any maintenance, she voluntarily gives up. So, in that case, the order for maintenance can also be cancelled. Next, subsection 4 of section 127 says, at the time of making any decree for the recovery of any maintenance or dowry by any person to whom a monthly allowance for the maintenance and interim maintenance or any of them has been ordered to be paid under section 125, the civil court shall take into account that sum which has been paid to or recovered by such person as monthly allowance for the maintenance and interim maintenance or any of them as the case may be in pursuance of the said order. This is simply giving some more power to the rights of the woman. It says that it is not only the maintenance that can be asked under section 125, but also can recover any dowry which has been given by the woman to the man on the marriage or after the marriage as well, and also recover any amount which is due as a maintenance as well. Before I move to the next section, let me remind this to all the guys and men who says there is nothing for them. Then read subsection 3 of section 127 properly. It's a kind of a shield, a safety to men. Read it again and you will understand my point. Now we come to the last point, section 128, enforcement of order of maintenance. It says that a copy of the order of maintenance or interim maintenance and expenses of proceedings, as the case may be, shall be given without payment to the person in whose favor it is made, or to his guardian, if any, or to the person to whom the allowance for the maintenance or allowance for the interim maintenance and expenses of the proceedings, as the case may be, is to be paid. And such order may be enforced by any magistrate in any place where the person against whom it is made may be, on such magistrate being satisfied as to the identity of the parties and the non-payment of the allowance, or, as the case may be, expenses due. In simple words, any order for maintenance or interim maintenance and expenses of the proceedings, as the case may be, can be executed by the magistrate. The big thing is, when the order for maintenance is made, he need not check whether he is within the jurisdiction or not. We come to the end of this topic now, and do not forget to check landmark cases from this chapter in my next video lecture. Enjoy your life, enjoy your studies, and do not forget to respect your parents.